Hello everyone and welcome to today's virtual annual webinar. We're delighted to be hosting this today with We Are Adam. So those of you that are joining for the first time through We Are Adam, welcome, and anyone else that's joining us for the first time, welcome. My name's Padma, I'm a Senior Associate here at Owen Mitchell and I specialise in employment and corporate immigration law. I'm joined by Glenn Hayes, who I'll let him introduce himself later on when he speaks, and he's the head of our Northern Employment offices in Leeds, Sheffield and Manchester. So, for those of you that have been to our seminars before, know that we like to use this opportunity just to give you a quick insight into the things that are coming across our desk, the issues that we've seen over the last year, and just doing a bit of horizon forecasting of what's due to come into force, just to make you aware so that you can plan for them moving forward. And hopefully today will equip you with a few practical tips and insights into how to handle those matters if they come across your desk too. Now, if we're in the office, naturally we'd have people putting their hands up, giving contributions of their experiences, asking questions and so on. Just because it's virtual, we want to try and carry on doing that. So please, if you've got any questions, do put them in the question and answers section. And Glenn and I will try and answer them as we go along, or we've got some time at the end also to cover them off. However, if you can also just put your name, we are the only ones that can see that you've asked the question and your identity effectively. But what that helps us do is if for whatever reason we are inundated with questions, which is what usually happens at these things, if we aren't able to answer it, we can come back to you at a later time and go through that with you, and especially if there's something that's a bit more fact specific there that needs covering off. So moving on to the next slide, the agenda for today, I'm going to cover Brexit and what that means for recruitment and your current EU staff. I'll also be touching upon IR35, which is a tax rule. So for those of you that engage contractors, this will be of interest to you. You'll have seen that last year this was due to come into force. It got pushed back, so I'll be covering what that means for you this year. I'll also be looking at changes to national minimum wage and just update you in relation to what to look for in April. And then I'll hand over to Glenn to talk about coronavirus and the issues that are still coming across our desk, as I say, so lockdown, shielding, vaccinations, those types of questions that are arising. Glenn will then also look at 2021 and do some predictions, and also just look at a few cases that are likely to have a big impact on the work that you guys will have as businesses, and also HR policies for those of you that are HR managers and directors on today's session. So moving on, the next two slides, please. We're going to just do a quick recap of 2020 because things have happened, but I think a lot of it has been dominated by COVID. So one thing that I realised last week is there's quite a lot that employers haven't really, they've missed because obviously and naturally the priority has been on coronavirus. So I thought this would be a quick opportunity just to go through a couple of things that have happened or are likely to happen that you may have missed. So do put your answers in the question and answers function if you want to answer along as we go live. So first question, what's the latest date you can issue a contract of employment? Is it day one or within 2 months? I'll just wait a couple of seconds for people to give some answers. So, I think the thing that some people have missed here is historically it was within 2 months of employment. Now, from April 2020, some changes came in, which we covered at the last webinar that we did, in that contracts need to contain more information than what they've historically had to. So there's additional requirements such as needing to include information about training, paid leave and those types of things. But also the requirement is certain information basically a lot of what's in section 1 and what is traditionally covered off in an employment contract must be given on day 1. There's odd bits and pieces that you can give a bit later on, such as pension details and so on, but on the whole there is a day 1 right to contracts, and that came into force in April 2020. So one to keep an eye on, and if your contracts don't cover the new requirements, then do give us a shout, because we might be able to help with templates and just go through your existing contracts. But also the new year is a good time to just do a quick refresh to make sure that those contracts are covering and protecting the business as much as you need it to, whether it be things like restrictive covenants and those types of things. So the answer to that is day 1. Second question, are casual workers entitled to receive a statement explaining their key rights? Yes, no, or C, might be in the future. So the answer to that one is also A, yes. So with the April 2020 changes, equally it expanded the scope as to who is entitled to section 1 information, and that is extended to workers. So the answer is yes in relation to that, and again we do have some template and precedent documents that we can share with you and look at with you if needed, so do get in touch. Number 3, what reference period should you use to calculate holiday pay for people whose hours vary? 12 weeks or 52 weeks? So interesting. I think several of you still think it's 12 weeks. It's actually now 52 weeks, another April 2020 change that came in. I'll leave Glenn to go into that in a bit more detail in later slides, but now you look at an average over a 52-week period to work out what that rate of pay should be. And finally, number 4, which workers can you not furlough? So we've got, can you furlough fixed-term workers, apprentices, supply teachers, public sector employees, or anyone with more than one job? Who is it that we can't furlough? So the answer to that is D. So because they're already in receipt of public funding for their role, there are some exceptions to this rule, but in general it's public sector workers that you shouldn't really be using furlough money for. So if you're an organisation that relies on any public sector funding, it's one just to keep a look at and see whether any of the exceptions apply to you. So moving on to the next slide. As I say, I'm going to cover off Brexit, and hopefully this is one of the last times I have to talk about what Brexit might or might not mean for organisations. And so in today's session, because we have obviously had separate seminars in relation to this and we've covered it on a number of occasions historically, this is going to be a bit of a whistle-stop tour, and in the session I'm going to concentrate on recruiting skilled workers via the points-based system that has gone live since the 1st of January. Because if you have any new entrants, so new employees that have entered to reside in the UK after it's actually 11 PM on the 31st December, they will fit into this new category and system, and it's going to be the most common way in which you are going to be employing individuals who fall into that category. Now, there are other routes that can be used, such as intercompany transfers, graduate routes and so on, and naturalisation or spousal visas. But as I say, the most common route is going to be skilled points-based system. So that's the one that I'll concentrate on. But if you do want to look at your options, do obviously contact myself, and we've got a bigger immigration team that sits in our southern offices, and we'd be more than happy to help you in relation to that, because it can be quite tricky. So moving on to the next slide, what does a points-based system looks like? The whole idea is around attracting talent. So what the Home Office has done is it said individuals who want to be sponsored to enter into the UK must get a minimum of 70 points. And what the Home Office have done, and they've always done this for rest of the world immigration population that want to be sponsored by an employer, and they have what is known as a standard occupational classification code. So there's a document that if you go onto the Home Office website that lists every potential job that exists, and it categorises them, and then it gives them a unique code. And then within that unique code, it sets out what the job description is likely to look like and what the typical responsibilities would be. And then it gives a minimum salary that must be attributed to that role. And so in terms of making up that 70 points, typically individuals will make up the points by the bullet points that are on the slides that you've got in front of you. So firstly, a job offer must be made by a licensed sponsor. So one thing that if you in the future are going to be recruiting EU staff, or you're heavily reliant on EU staff, or even further afield now, because there's no distinction effectively between Europe and rest of the world. The only distinction we've got is Ireland, where this doesn't count. But beyond that, as I say, anyone that's not lived and resided in the UK before Brexit are now subject to this new system. And so employees will need to register to become a licensed sponsor. And on the next slide, I'll go on to the costs and what that looks like. But if you are someone that's reliant, as I say, on that workforce, you need to probably start thinking now about becoming a licensed sponsor holder, because it takes about 4 to 6 weeks as a minimum to get that license. There are certain fees and exceptions where you can pay to expedite that process, but you are still very much at the mercy of the Home Office having that capacity, which is also naturally reduced during the coronavirus pandemic. So advanced planning is key to this, and also if you're in businesses. So I've had a few clients that say, actually, should we look at it speculatively? Even though we don't have anyone right now, we are in a position where if the business come to us and say we need a job, it'll be we need a job and we need them to start next week type of thing. So again, you might want to think about, do you need to apply speculatively even if you don't have a job in mind at the moment? So the first one, as I say, a job offer from someone that holds a license, and people get 20 points for that. The job must also have a minimum level of skill, so it sits at A level or equivalent, and again you get 20 points for that, and then meet the general salary threshold. So the minimum is 25,600, or I mentioned the SOC codes earlier, which is the list that the Home Office give. If that gives a higher rate, such as 30,000 for example, then you go with a higher figure, and then you get 20 points for that. Now in terms of that amount, that can be varied with other skills and qualifications. So for example, if there's a shortage occupation list, so the Home Office regularly update their list of jobs where we desperately need them in the UK, and in those cases they allow for a lower salary, but at all times it never drops below 20,480. So the key to this is looking at that Home Office guidance, looking at what the salary rate is and meeting that, unless there are any exceptions where you can sort of trade those points to build it up in other ways, such as the shortage occupation list. And then finally, an ability to speak language, so English language. So it might be that you have people either showing that they've had their degree taught in English or need to sit a separate test. So going on to the next slide, as I say, in order to sponsor individuals, employees need to hold a sponsor licence. And on this slide, I thought it'd be helpful just to set out what the costs might look like, because actually it is not a cheap affair in terms of if you are now needing to sponsor people from outside of the UK. So first cost will be a sponsor licence, which can sit between the 500 and 1,500 mark that's there on the slide. And that will depend on your size of organisation, whether you're a charitable organisation or not. You've then got to issue a certificate to the individual to show that they are going to be sponsored, for them to then be able to go off and get their own visa. That's £199. Each year, you've then got to pay what is known as an immigration skills charge, and that's £1,000 per year So the first year you've got to pay for the full 12 months, even if someone comes into the UK for a shorter period than that, and then you can do it in £500 blocks for 6 months thereafter. Those costs cannot be passed onto the worker. In addition, the employee will then have their own costs of applying for their own visa, which can be up to, again, another £1,500. Show that they've got enough money in their bank account to fund themselves to live in the UK and support themselves. And also there's a health surcharge of just over £600 that they've also got to pay. So as an employer, if you're also supporting them to cover that fee, as you can see, it does add up. One thing that I must probably say, and that we've seen a lot of, is employers saying, well, can we automatically at the sifting stage say we will not sponsor people and we won't welcome applications from outside of Europe? The answer to that is no, and it's something that I think needs to have some careful wording in your adverts, and that there are ways of looking at that, which again, more than happy to look at with you. But having a blanket ban of we will only now sponsor UK citizens runs the risk of a discrimination claim. So asking about those things or having that blanket ban, just be very careful of doing that, because that could land you in some sort of trouble. Moving on to the next slide then, what about staff that you have, what about if you've got European workers and anyone that has already entered the UK before 11 p.m. on the 31st of December, are subject to the existing rules that you've always been used to, so their European passport will be enough for you to do the checks and continue employing them. And at the moment, again, we've had a lot of employers worried about, do we quickly need to go off and get checks and make sure that they've applied for pre or settled status? And the answer is no. So just taking a quick recap, anyone that is already in the UK or has been in the UK before the 1st of January, unless they've got indefinite leave to remain, which I know is one of the questions that's popped up, unless they've got indefinite leave to remain, they must apply for settled or pre-settled status. So those with permanent residency, for example, and have been here for a long time, they would have to apply for settled or pre-settled status. And so unless indefinite leave to remain, naturalisation or any other rights, they must apply for this. And settled status is where they've been in the UK for 5 years or more and haven't been outside of the UK for more than 180 days within that period, or on a yearly basis. And pre-settled status is if they haven't, again, got that 5 years service or length of residency in the UK, but again, in any 12-month period, they must not have been outside of the UK for more than 180 days to make that application. There's no fee payable, and it's relatively straightforward now to make those applications, and they can do it on their phone. But as I say, it's something just to educate staff, make sure they know that they have to be applying for something, because some might be mistaken, for example, if they've got permanent residency and think, I don't need to apply. But they have until the 30th of June to make that application. So don't be worried if individuals haven't started that process yet, because they've still got some time. So one thing that the Home Office guidance currently says is you must not ask individuals to prove that they have made an application for settled or pre-settled status and sort of badger them in relation to that. And doing so might run the risk of a discrimination claim. So what you probably should be doing now is educating your staff and encouraging them to look at it or come to you if they need any support, so you can direct them in the right places or talk to them about what it might mean for them. And you can certainly encourage them to share whether they have applied for settled status or pre-settled status and give you that evidence. But at the moment, you cannot ask them to formally confirm whether or not they have done so, just because they still have time to make that application. So looking onto the next slide, as I say, you can't insist until the 1st of July. And what the Home Office have said is, because at the moment you can carry on relying on European passports, there isn't a right or a requirement for you to do retrospective work checks. But the problem with that is when you get to the 1st of July, if someone hasn't made a proper application for settled or pre-settled status, there's an argument there that you are employing them illegally. Now, I know that us as a firm, and I know many other firms, have contacted the Home Office to say, well, what will happen in that scenario where you're telling us not to do retrospective checks, but actually someone hasn't made their proper application because technically they are illegal. And so I think in the coming months, the Home Office will provide, or we hope will provide, further guidance in relation to that, because there is a bit of inconsistency there. But for now, I think the recommendation is, as I say, don't force employees to tell you, but you can certainly encourage them. And we can work with you if needed on how that communication with staff should look like. But come 1st of July, we would recommend that you do contact staff that fall within this category. And I think you are at that point entitled to say, we now need to know whether you've applied for settled or pre-settled status and provide us with evidence. Now, that evidence won't be a physical document, it'll be a code that the employee receives that they can then share with you. And I've actually done one this morning where you go on, you get a code, you go onto the Home Office website, put it in along with the date of birth of the individual, and then it just pulls up, nothing fancy, just an A4 piece of paper with the individual's photograph on, and just sets out what status they've got, whether it be settled or pre-settled status. And then you can download that and keep that on your HR system. So do look out for further guidance to come out in relation to this. And I regularly put updates on things like LinkedIn, and we send out Parental articles. So at the end, we'll give you a feedback form to fill out. So if you are interested in further information in relation to this, just put that on there and we'll just be mindful to make sure that you're getting those updates. So next section that I wanted to quickly run through is IR35. So going on to the next slide, please. We have previously discussed IR35, and I can probably talk for a whole morning in relation to IR35. We will be running some separate seminars in relation to this, and also providing some further guidance and update to those of you that are IMHR Plus clients. And by all means, again, on your feedback forms, if you want some further information or be invited to our update seminars in relation to IR35 specifically, then let us know. But in summary, those of you that have joined us before will know that IR35 is not a new piece of legislation. It's been around since the year 2000. But what the Home Office was struggling with in terms of collecting tax was people setting up an individual limited company. So, for example, I could set up Padma Limited and provide my services through that conduit to Owen Mitchell as the end user. And what was happening was, because of the tax and NI benefits of doing that, HMRC were effectively losing out. So I could set up this company, but to all intents and purposes, sit there and behave like an employee or worker, providing my services Monday to Friday solely for Owen Mitchell, and do everything that an employee would do. And so to tackle that, a few years ago, the HMRC brought in some new changes, and they brought that into the public sector to start off with and test it with the public sector to say, what you now need to do is remove that limited company or the conduit in the middle, and then look at the relationship between the individual and the end user. And if looking at that relationship and applying certain tests, such as, you know, how often are they providing their services? Do they provide their services to other people? Do they get equipment from the company, or do they provide it themselves? Once you've done that test, if you find that they are actually, or should be, a worker or employee, we are going to put the responsibility on the end user, so whoever is using the service, so in this case it will be you as the organisation engaging the services, to account for tax and national insurance to HMRC. We'll take that responsibility away from the individual and that limited company, so Padma Limited will no longer be, well, not that they won't no longer be responsible, but they will be responsible, but in the first instance we will turn to the company, the end user, to account for that tax. And so from April 2021, because as I say, it was due to come into force April 2020, with coronavirus, they just kicked it back. And so from April 2021, the onus will be on the end user to look at that relationship, determine what that relationship looks like, document it on what is known as a status determination statement, setting out what factors were considered to be able to say, yes, even if we remove PAVMA Limited in the middle, you are still self-employed, or actually, no, you're not, so we need to now start accounting for tax and national insurance. Give that statement, give an opportunity for the individual at the end of it to challenge that status that you've determined if they think it's incorrect, but ultimately make that decision and then start paying national insurance and tax at the end. So this will only apply to certain companies in the private sector from April 2021, but it will cover a large number of companies. So a company must meet at least 2 of the following criteria. Number 1, the annual turnover of more than 10.2 million, a balance sheet of 5.1 million, or has more than 50 employees. So 2 out of those 3 criteria need to be met. And as you can see, it'll probably capture quite a lot of companies. So if you fall within those categories and you engage service workers, you really need to start paying attention to this now, because having helped clients prepare for this when it was due to come into force in April 2020, doing those status determination tests, working out who you need to start accounting for or not, can take some time. So moving on to the next slide then, what do you need to think about? As I say, I appreciate this is a quick whistle-stop tour, so we will be covering this in further detail in separate seminars, but I guess for now, the bullet points and things you need to consider is look at whether as an organisation, if you fall within that category, so it's medium to large size organisations. If you fall within that category, do you engage service workers through those limited company type arrangements? If so, you need to start thinking about how you're going to assess those relationships and who is the best person to do that exercise. So you need to think about whether it's HR, or in other organisations, HR is sort of removed a little from the contractor work that your organisation engages with. And if so, who is that person that will know what that relationship is like? And are they equipped to make those decisions? So do they know the types of tests that you need to apply and look at? Or do they need educating in relation to that? And sometimes it might identify that just with a few tweaks here and there, it's all the difference between falling under genuinely being self-employed or potentially a worker category. So does that exercise need to be done, and can we start making changes now? As I mentioned, people can challenge the status that you give them, and if they do, who's going to look at those appeals? Is it going to be within the company, or do you need to engage someone external to take that independent view for you? What does it mean in terms of your contracts? So again, some contracts have come across our desk where the contract makes no reference to if tax needs to be paid, that can be deducted from the fee that's ultimately paid to that limited company and contractor. So who will pick up that tab? Do you need to renegotiate those terms? Because otherwise, are you at risk of that being an additional cost to you as a company? So it increases that baseline cost of engaging that contractor for you. And also, can your payroll and account system deal with those changes? So are all your systems set up to deal with this? So it's something that really needs attention now, even though we've got a few months. But if you fall within that category, then certainly something you need to start looking at. As an organisation, as I say, we've got some webinars coming up, and we've started putting together some template documents and guidance notes that companies can use to do these status tests and look at where the risk factors are. And equally, a few of us in the team have done quite a lot of these in terms of helping organisations basically put together a bit of a red flag report. So looking at what tests actually you need to look at changing your practices potentially, or put you at risk of falling in an employee category, and what practices you do well, so you need to carry on doing moving forward to sit on the right side of IR35. So again, if you're interested in that, let me know, and I'm more than happy to have a further chat with you about that. And then finally, before I hand over to Glenn, if I can just move a slide on, I just wanted to quickly touch upon national minimum wage. So from April 2021, the national minimum wage regulations will start applying to anyone that's 23 and over. And historically, that age figure was 25. So just want to be aware of, because that will potentially increase some of your staff costs. Moving on to the next slide, in that slide I've just set out what those changes are going to be. So I won't run through those because you've got those on the slides there. But as I say, the main point to note is actually the national minimum wage will start to apply from age 23, sorry. And also in April, the usual changes to statutory maternity pay, sick pay, etc. will also apply. So again, just want to be mindful of. I'm now going to hand over to Glenn to look at the coronavirus and some of the questions and issues that we're coming across in relation to that.
Thanks, Padma. So thanks, Padma. I'm going to deal with the coronavirus then. I'm just going to start off with a sort of general overview then. So obviously we've been in lockdown now since the 6th of January, although it might feel like longer to everybody. And it's likely to be in place until March as a minimum. So in terms of the guidance that have been produced, the businesses are providing services rather than goods can remain open, but the stay-at-home guidance still applies. And the legislation obviously requires people to work from home unless it's not reasonably possible to do so. So there is some legislation that sets out those businesses that have to close and those that can stay open. But remember that the businesses that provide services rather than goods, some of those can remain open, but it's still subject to an overarching rule that the general work from home rule is still in force. And the guidance that deals with that says that you may only leave your home for work if you cannot reasonably work from home. Okay, so we're seeing quite a lot of information in relation to this. There's still the requirement in any event for employers who do remain open to comply with the guidelines on working safely. And again, they were updated on the 1st of January. There is the legal right to travel to and from work if it's not reasonably possible to work from home. And it's not a defined concept that it's subject to interpretation. But one thing we are seeing is that I think it's very difficult for employers to argue that staff who previously worked from home during the first lockdown can't do so this time, even if those arrangements were less than perfect. But if you engage sort of employees who live in cramped conditions, are worried about domestic violence or have mental health problems, and that last one's an increasing issue now, you might be able to allow them to return to the workplace providing it's COVID secure. But you shouldn't really be insisting that staff come into work unless it's necessary, even if your premises are COVID secure. Remember that individuals can be fined if they're travelling unnecessarily. And we've heard evidence that a lawyer was stopped at Euston Station, for example, and asked by the police why she was travelling, but she had a court hearing and therefore she had a reasonable excuse. So the police do seem to be taking proactive steps to deal with this. And I think that's amidst a general view, sort of an increasing view, if you like, of employers seeing the benefits of people coming back into the workplace for some or all of the time. So if you do require people to come into the office, it might be helpful to give them a letter explaining why they need to do so, so that if they're stopped by the police, then they've got some evidence in that regard. Just move on to the next slide, James, please. So the guidance in relation to shielding has also changed, and effectively that shielding program's restarted. So clinically extremely vulnerable people have been told to work from home, and if they can't work from home, they've been advised not to go into work, which obviously was the position originally, but then changed and is now back to the original position. So the options available for employers, I've set them out on the slide there. So I just want to flesh them out a little bit though. So you can allocate different duties that can be done from home by agreement. Just remember there, in any event, you may have a duty, or you're likely to have a duty in relation to shielders anyway, to make reasonable adjustments. And so if there is some alternative duties that can be given to that individual, you might be under a legal duty to do that anyway under your obligations under the Equality Act in respect of that disability. They can be furloughed, and it's been clarified that providing that they meet the usual criteria, and by that I mean, if they're in employment by the required date, you've submitted the necessary information to HMRC, those individuals can be furloughed as an alternative to effectively being placed on sickness leave. And you can potentially place them on paid holiday or pay them SSP. I just wanted to talk to you about one of the big issues though that's come up in the last, and I don't have a slide on it unfortunately, but it's come up particularly over the last couple of days, and that's the issue of the vaccine really. And this is a huge issue for employers in my view, as the vaccine increases and and it starts to be given out to larger portions of the population. Last week, the outspoken owner of Pimlico Plumbers said that he wouldn't offer a job to anybody who hasn't been vaccinated. And it's really difficult for employers, and we're starting to see a lot of questions come through and issues that employers are grappling with as to whether or not they can do anything if staff refuse to effectively have the vaccine. Now, we've issued some guidance on LinkedIn recently, so if you follow us on LinkedIn, you'll be kept up to date in relation to that. But the National Care Association, for example, is currently taking advice as to about whether care homes can force their staff to have the vaccine, after it emerged that up to 1/5 of the staff in some care home groups have refused to take it. Now, if you look at what the government said about the vaccination process, there's no legal basis on which the government can force people to be vaccinated. So that's the first point. And obviously what the government sought to do is trying to persuade everybody that the vaccines are safe, and it's in everybody's interest to get one so we can get back to some sort of normality. So if the government can't compel people to be vaccinated, you can't obviously frog march your staff to the nearest vaccination centre either. But the government hasn't published information yet which is directed at the general public. Okay, but what it has done is it's produced guidance for frontline healthcare workers, and that's quite instructive. And what that's done is explain the benefits of being vaccinated for the individual. And it says that the benefits are that it reduces the chance of catching COVID or becoming seriously unwell if they do so, and to the wider population. So there's benefits there. So they're less likely to infect the family, friends, vulnerable people they care for. But there's no specific health and safety at work guidance about the COVID vaccinations. For example, the Health and Safety at Work Act doesn't deal with it, whilst it requires employers to take all reasonably practicable steps to reduce workplace risk. It doesn't include procuring the vaccine. And in any event, it will be extremely difficult anyway, given the huge worldwide demand. But what it does say is that staff should be encouraged to take the vaccine when it's offered to them. So what does it really mean for employers? Well, it doesn't mean that you should just relax your efforts to make your workplace COVID secure as the vast majority of the population are vaccinated, because those precautions still remain the best way of protecting your staff. But the question remains as to whether it's a reasonable instruction to ask staff to take the vaccine. And I think that's a really important issue, because as a matter of contract and employment law, if you can establish that asking the staff to take the vaccine is a reasonable management instruction, if the staff member refuses, you might be able to justify taking disciplinary action against them for that refusal. Now, my view on this depends really on a number of factors, and I think the most important of those factors is whether the vaccination is going to protect other members of staff or people that come into contact with, rather than just the individual themselves. So if you are in the healthcare sector, for example, and looking at what the government guidance so far says, and the World Health Organization guidance says, is that the vaccines reduce the overall risk of infection and reduce the risk of passing the virus on, albeit that second element is less clear. The World Health Organization says when a person gets vaccinated against a disease, the risk of infection is reduced, so they're less likely to transmit the virus or bacteria to others. So it's not just about the amount of risk to the individual's prepared to take by choosing not to be vaccinated. I think you do consider the effect of potentially passing this on. Now, look, that said, at the minute we're just verging into the categories of the over 70s about to be vaccinated. So there's a huge sway of the population not even up for consideration as things currently stand. But as those numbers start to creep up, you can see a position where groups of staff will potentially refuse to be offered a vaccine. And my view would be, you really need to consider with that individual why they are refusing to have the vaccine, and specifically whether it is genuinely a reasonable request for your staff to be vaccinated. Because in my view, if you want to take action against that member of staff if they refuse to be vaccinated, you will have to look at the specific reason for the refusal. So, for example, you might have pregnant women where it's still unclear. You might have some key groups of society, such as Black individuals, where SAGE have found a vaccine hesitancy to be at its highest in Black or Black British groups. You might have people who are of a certain religion refusing it on the basis of their religion or philosophical belief. You might have people whereby they can't have the vaccine. I think it will be extremely difficult to take action against those people because of the specific disability that they have, or part of the population that they are a part of. So I think you need to take the process extremely carefully in considering whether it's a reasonable management request and whether you can effectively insist on people being vaccinated. Just remember also you'll need to comply with GDPR rules on process and special category of data if you're requiring people to inform you that they've actually had the vaccine, so you can keep it for only as long as is needed, for example. And you need a really good reason, in any event, a lawful reason for needing to know the answer as to whether somebody's been vaccinated or not. So a really tricky issue, and one I expect fully to evolve over the weeks and months to come. But it's sort of watch this space and we'll keep you up to date, really. If you move the slide on, please, James. So the furlough scheme obviously remains in place. It's due to end on the 30th of April 2021. There are some requirements in relation to that. So you need to be on the payroll by the 30th of October, and you don't need to have been furloughed under the original scheme, which is important. It's now been clarified that you can furlough staff who are ill, other than for short-term illness, although there isn't really a definition for that, who are shielding or have caring responsibilities. And that caring responsibilities point is really important now, because what employers are finding is that lots of people have had their children sent home, for instance, with primary and secondary schools closed. Currently, I've dodged a bullet, but I accept it's a temporary reprieve insofar as my two children are at nursery, which remain open for now at least. And staff and employers might want to use the furlough scheme to effectively furlough people who need to be off work or cannot work by virtue of the fact they're caring for primary or secondary school children and homeschooling. So it's a really difficult thing to do to homeschool and continue to work, and employers might want to use the furlough scheme to do that unless and until the schools reopen. You can't, however, use it if an employee serving notice for whatever reason. So just be careful in relation to that. Originally, you could use it if you were serving notice for redundancy, for example, but you can't now do that, and the government's made that specifically clear. What they've said is that the scheme shouldn't be used for those people who are ill for a short period of time. So self-isolation shouldn't be a consideration in whether to furlough an employee. But if you do want to furlough employees for business reasons and they're currently off sick, you can do that. Okay, they should no longer receive sick pay and will be classed as a furlough employee. And those business reasons mean that you can furlough staff even if they're ill for only a few days, if you're furloughing your entire workforce or the part of it that they work in. So it does get you around that potential short-term issue if you need to do that. If you can move the slide on, please, James. So the job retention bonus that the government put in place originally, where it was going to pay £1,000 to employers who retain furloughed staff until at least the 31st of January 2021. That scheme has currently been abandoned. We don't know whether it's going to be put back in place or not, but that's been abandoned in favour of extending the CJRS scheme. And we don't know yet whether that's another similar scheme will be available once the current furlough scheme ends. It's again, watch this space. If you move the slides on, please, James. So the other thing that the government did was they amended the work and time regulations to allow the employees to carry over up to 4 weeks accrued holiday leave into the next 2 holiday years if they were unable to take that holiday in the 2020 holiday year because of the effects of the coronavirus. So it only applies to the 4 weeks holiday under the work and time regulations, not the additional leave under the UK provisions. But ordinarily, workers can only carry over leave from 1 year to the next if they're too ill to take it. But the government's extended the exception if it's not reasonably practicable to take it. And that's a widely drawn definition, and that applies where coronavirus has affected the worker, their employer, the wider economy or society. So it's really wide. But just be careful because it does only affect that first 4 weeks. And if your contracts set out the order in which people can take holiday, okay, then staff will only be able to take the carryover holiday if they've not taken the 4 weeks. But if they haven't, then it's up to you as to how much they carry over, and check your policy in that regard, really. If you can move on the slides, please, James. So I'm not Mystic Meg, but I am going to try and look forward to the things that we know are on the government's potential agenda. So an employment bill was announced in the December 2019 Queen's speech, which included a number of potentially radical changes. And the ones that are set out on that slide there, none of those yet have been brought into force, but it is possible that the government will revisit these issues later on in the year. So the government consulted in 2019. I'll just pick one of those, which I think is probably the most important, on extending redundancy protection for employees taking maternity leave and for other new parents. Okay, so it committed to extending the period of protection so that it would apply from the point the employee informs their employer that they're pregnant and continue for 6 months after the return to work. So that would be quite a wide ranging change in my view. There's also potential extensions to the protection periods for those taking adoption leave and shared parental leave. So we don't know whether these are going to come into force yet, but it was certainly something on the government's agenda before the world went into meltdown effectively. And we do expect these things to potentially come back in and into consultation further on in this calendar year. If you move the slide on, please, James. Padma's talked about the dreaded B word and Brexit. I just wanted to briefly touch upon the impact on Brexit on UK employment law, and to assure people really that there is no immediate impact on most aspects of employment law, UK employment law. But what the government is able to do is it is able to legislate to change employment rights, and the Supreme Court and the Court of Appeal, which obviously sets binding authority for us in this country, can choose not to follow EU law as a matter of principle, albeit they still have to operate within that level playing field that's been provided for in the Brexit negotiations and the deal that was eventually reached. So in my view, the pace of change in relation to EU employment law and how it impacts us is likely to be slow. But the Withdrawal Act does confer the power on the UK Supreme Court and the Court of Appeal to depart from that retained case law if it's right to do so. So the idea is that it'll still be quite hard to dismantle employment rights without consequences, but there is provision to allow them to do so. I do think it might affect areas like holiday pay, possibly agency workers and the like. So again, we'll update you as soon as the impact becomes a little bit clearer in relation to that. If you move the slide on, please, James. So in relation to the case law, then I just want to briefly go through these under the next slide, James, and to touch upon the cases that we do know are coming through this year and why they're important to businesses. So if you remember, in the holiday pay and overtime cases, in the holiday pay and commission cases, there was an argument that was used in Bear Scotland and others that effectively allowed, it was a technical argument that reduced the liability of employers who had underpaid the staff to the current holiday year only. So if there was a break in the series of deductions of more than 3 months or more, if it was the 21st day of holiday, which effectively stopped the EU provision of holiday, or if effectively there was the 20 days had been used, there was more than a 3-month gap between the next holiday, then effectively that would break the series of deductions, and it would therefore be limited to 2020 rather than 2021 when we start over again. The Northern Ireland case of Agnew effectively tore that up and said, no, that doesn't break the series of deductions. Okay, and the Northern Ireland decisions aren't currently binding on England and Wales or Scotland, but the Supreme Court's decision will be. And this case of Agnew is being heard in the Supreme Court on the 23rd and 24th of June this year. Now, whilst it's being heard on that date, the Supreme Court are really slow in getting out judgments generally. So it's possible that we won't know the answer to this year, but it is something to watch out for. And if you do operate overtime payments or commission, and you don't pay those in holiday pay, then you might be storing up liabilities. So you do need to keep an eye on this and keep an eye on the material that we produce in relation to it. If you move on to the next slide, James, please. The other case that might be significant to some people is the case of Brazil against the Harper Trust. If you remember, this is the case where it dealt with the potential ability to prorate the holiday entitlement of part-year workers, such as those on term time contracts. So, for example, if you're in the teaching, the education sector, this case involved a teacher that was engaged on a term time contract, entitled to 5.6 weeks holiday per year under the working time regulations, and the employer argued that should be prorated down because they're only working 39 weeks of the year. And the court decided that actually you couldn't, the Court of Appeal decided you couldn't prorate that down or apply the 12.07% formula for working out holiday entitlement. So if you do have employees on term time or other part-year contracts, then this clearly is a massive potential case for you, and it's something that needs to be aware of. You need to be aware of. The Supreme Court are due to hear it on the 9th of November, and it'll be interesting to see what they decide in that regard. Just move it on a little bit, please, James. The other case of potential relevance to some people would be this case of Mencap and Tomlinson Blake, which relates to the national minimum wage and what happens to people on sleep-in shifts. So it's not just the care sector; it might be security, it might be other types of industry where you have sort of passive workers, if you like. So the current position is that workers are either working or available for work, and if they're sleeping, okay, they're only available for work, and they're not necessarily entitled to the national minimum wage. So the Supreme Court actually heard the case in February of last year, but it hasn't published the judgment as of yet. Okay, so the current position is that you only are paid if you have to get up during the night to help a patient in this case, or do some other work, not if you are genuinely sleeping. But again, that was a departure from the earlier court in this decision. And it's something that employers will need to be kept aware of if it does impact them, because it will expose them to claims for underpaid staff for potentially up to 6 years if they fall within that category. If you move on the slide deck, please, James. The other case that people won't really have escaped at all is the Uber case, which is a decision that was heard by the Supreme Court in July 2020. But we haven't yet got the judgment yet. So just as a reminder, there's 3 categories of people for employment law status purposes. So we've got employees that have effectively got all the rights, workers that have got some rights, and those who are self-employed who have got very little rights. So it's important to work out the status of your employee, of your workforce, to work out what rights they've got. If you remember, Uber's argument was that it was a technology platform, not a taxi service. So it says it just effectively puts passengers in touch with drivers, and therefore the workers that the drivers are effectively self-employed and they're free to accept or reject work. But if you remember, the Court of Appeal said that actually that's not the case. It was effectively those individuals were deemed to be workers. Okay, so they were required to provide personal service. Okay, now the Supreme Court, so far the courts have been unable to devise a single test that conclusively points to a distinction in all cases. And whilst I strongly suspect that this case won't provide a single test either, it should hopefully provide us with some guidance that other companies can then adopt to determine whether the self-employed contractors that they believe are self-employed are workers or entitled to some employment rights. If you move the slides on, please, James. The final case that I wanted to touch on was this case of the collective bargaining case. So those employers that are unionised this will be of relevance for, and this concerns a case where the negotiations are broken down with the union, between the employer and the union on behalf of the staff, and the employer went directly to the staff to negotiate, and thereby short-circuiting the union. And originally the court had decided, well, actually that fell foul of the regulations, because the employer has to negotiate with the union, and then the Supreme Court have now heard this case, but the Court of Appeal effectively had said that employers can approach the staff directly to agree temporary changes if the negotiations with the union break down. So the Court of Appeal held that the unions can't prevent that from occurring where the negotiations have broken down, because effectively the unions were arguing they had a veto, and it was very difficult for then employers to change even minor terms and conditions without the union's agreement. Now, the Supreme Court is due to hear this appeal on the 18th of May, and if it is upheld, then employers have a bit more options if they can't agree terms with the union. So, James, if you just move the slide on again, please. So the to-do list, really, in relation to all the matters we've discussed there, I've set out on the slide. I'll just leave that up on the slide, and I'll ask Padma to join me as well in relation to the questions. So in terms of some of the questions that we've had, interesting question in relation to a general, can we send a general email to all our employees asking what their intention is in respect of getting the vaccine? Well, I personally don't see any harm in asking what the intention is. I do believe there might be some harm in then whatever you decide to do, depending on what the answer is to that. So I think that would fall into the category. But I think you could, in my view, ask what the intention could be in relation to that. Another question we've been asked is whether there's any anticipated change to TUPE legislation. I assume that's a question in relation to the impact of Brexit. Well, again, I don't think there'll be any wide-ranging changes to TUPE generally as of yet, but I do think that when TUPE was introduced, obviously it was very much a European-style initiative, and I do think that it is one where where employers may form a slightly bigger lobbying group in relation to TUPE, for example, to provide a bit more structure as to the tests that are to be applied, albeit the codifying of that specific test has been tried for a nigh on 30 years and nobody's come up with a decent way of doing so. So I think that might be somewhat difficult. Padma, do you want to take any of the?
Yeah, so a couple of questions, just going back to the slides that I covered. Someone's just asked about the English language test, or there's a couple of questions in relation to the English language test. The point to that is 10, and it's a non-tradable point, so it's a mandatory. You must demonstrate English language. Unlike, as I said, salary, you can trade the points off if you provide a lower salary because they're in another category, such as shortage occupation list. And are there minimum thresholds of what that English language test looks like? So if you go onto the Home Office website, it's a whole list, which is probably too long to run through during the session. But if you're from an English speaking country such as Canada, America, etc., then that would be enough to demonstrate that rule. Or if you've got a degree level that was primarily taught in English, again, you'd get over that hurdle by showing that you've got that degree. And otherwise, it's sitting a Home Office test, so you can go to a test centre, book in, and then they have their pass rates there for doing that, and they just give you a pass or fail in relation to that. In terms of, there's a few questions just in relation to that are quite specific in terms of, can people rely on spousal visas or letters from the Home Office or what would have been the UK border agency, etc. back then. from 1997 to say someone has the right to be in the UK. I think those are very fact specific, so we'd need to look at the exact visas and when they were granted and what that wording says to be able to advise you on that. And so by all means, we're happy to pick that up with you, but I think that will need to look at the individual circumstances for those.
So I'll just take a couple more because I'm conscious of time.
Yeah.
So one of the questions that we've been asked quite a bit is whether you can force staff to have a COVID test to go into work. Well, again, I don't think you can force people to take the test, but I do think that if you work in a sector that is particularly risky and individuals cannot work from home, then I think you can potentially at least require people to take tests as being a safe way of being able to work. I think if there are any symptoms, clearly you'd have to send people home in any event. But I think it depends on the type of industry that you're in and the risk that they pose. And I think that risk, in theory, should reduce down over time the more of the population get vaccinated. But I think that's a really tricky one. I noticed the person that asks from an education background, or from an education establishment. So, or one of the people that has asked anyway. So I think I would tread carefully. I don't think you can force them to have a test, but you might be able to suggest that they either have to work from home or you may need to take action if they can't demonstrate that they've got that they are coronavirus free.
It depends on the level of interaction, doesn't it, Glenn? Because challenges that I've had with a few clients is saying, well, you're telling me I'm working in a COVID secure environment, so that should theoretically mean that we've got a 2 metre distance, masks, all that sort of stuff. So as long as I'm not exhibiting symptoms, there's no need for you to then force me to do a test. So I think you need to do a balancing act, because it might then do the opposite as well, of people sort of saying, well, fine, I'm taking these tests, so I don't necessarily need to comply with some of the rules, or actually I'm now worried that you're telling me that I'm not in a COVID secure environment.
Yeah, I think it is a bit of a balance, really. One of the questions that's been asked as to whether you can furlough people who've only worked for certain parts of the year, relief staff. And I think that would depend entirely on whether or not they were in your employment on the given date and had submitted those real-time information to the to HMRC.
And I think just a quick one to cover off is about carryover of holiday, because we've had a lot of questions in relation to that, because right at the beginning of the pandemic, there was guidance to say people can carry over up to 4 weeks of holiday. And that was very much bought for industries like people that are working in healthcare sectors, shops and things like that, where there were key workers that need to keep going. So taking holiday wasn't necessarily an option. So it's where it wasn't reasonably possible to take that holiday. So I don't think you need to apply that rule to everyone. You need to take that balance of what was there a reason that we were stopping them from taking that holiday. And in terms of how it interacts with furlough, which is one of the questions here, is you can still ask people to be on furlough and take holiday. If they're on holiday during furlough, you need to top up that furlough pay, to 100%. So just because someone's on furlough doesn't mean that you have to allow a carryover, subject to whatever your policies are as well. So if most businesses allow the 5-day carryover, you still need to allow those. But just because someone's on furlough, it doesn't mean that they can't take holiday, even though it's obviously not the ideal holiday we'd like to be taking.
Well, it's the worst holiday ever, in my view. I'd like to be sitting on the beach, but hey ho. And so I'm conscious of time. We will respond to the individual questions directly for those guys that have left the names. The other thing that would be useful from my point of view is there is a feedback form, which we'd ask you to fill out if you could do. The other thing is, if you connect with either myself or Padma or both of us on LinkedIn, you will get our regular updates on LinkedIn on things like the vaccine and things like changes to Brexit, on things like the immigration rules, as and when they evolve, literally on a daily basis. You can choose to look at them or not at your own leisure. And it would also be useful to us on LinkedIn, if you could do, if you've enjoyed today's seminar, just to link in with us and just put a couple of comments on about the seminar and tag us on those. That would be really appreciated. A big thank you to We Are Adam, who we've hosted this event with, and I hope you've all found it useful. It's obviously a lot of information in a short period of time. If you do wish to get us in touch with us, our contact details are on the slide there. We'd be happy to help talk to you about our services or any issues that you've got in your business, and share some of the issues that we're seeing on our desks on a fairly regular basis. Just to comment on one thing that Padma picked up on the IR35 stuff. Do watch out for this space, because that is going to be a big area that we're going to focus on this year with the changes coming up. We are about to launch a product that involves a review of people's status, that RAG report that Padma was talking about. So if people are interested in that, then again, they can give us a bell, and we'd be happy to share some further details with you on that. Just leaves me to say thank you for listening. We've got a really good turnout on this. We hope you enjoy it. If you are interested in joining us for our senior HR clubs and our general updates, then just drop us a line. We'd be happy to add you to the mailing list for those. Hope you have a good day and stay COVID free. Thanks a lot.